what's unique about this case is the fact that, number one, the Ohio Public Defender was cooperative enough to agree to allow one of their staff attorneys to actually come to Licking County, where we do not have a public defender's office, to represent Mr. Bishop, because Mr. Bishop has now blown through, on one case, let's see, 1, 2, 3, 4, 5. Mrs. Ilola would be the 6th attorney that had been appointed to represent him. In the other case, at the very least, she would have been the 5th attorney that was appointed to represent him. The court does not force attorneys to continue with representation when they feel that there cannot be an adequate resolution. Furthermore, the defendant has expressed his displeasure. Now, at this time, I am going to grant the motion to withdraw, and Ms. Ilola, if you would like to leave, you're free to go.
Thank you, Your Honor. Before I do, though, I do want to make a record. Mr. Bishop did hand me a lot of materials to look over, which I did do so for his case. I would like to hand them back to him on the record, just so that way we do not have any further issues going forward. This is everything, including the flash drives that were given to me, and then including the new motions that were addressed for this is the motion of withdrawal that was sent to you also, but I wanted to give you a copy of it in person as well.
And Mr. Bishop, are you satisfied that Ms. Ilola has returned everything that you had provided to her?
I believe so, Your Honor, with a quick glance over.
Very well. Counsel?
Your Honor, I just wanted to make sure, clarify, does that include all the discovery provided by the state?
I believe so. Based off of what I was given by Mr. Bishop, I believe that's all the discovery as well.
All right. Thank you, counsel.
Thank you very much, Your Honor.
Okay, so a couple of matters that we need to address. Number one, the defendant, pro se, prior to the withdrawal of Ms. Ilola's counsel, filed a motion to enforce. That was filed on the 16th of January. In essence, the defendant is asking this court to order a different court to take action, to take legal action. This court has absolutely no authority to do that. Certainly, the defendant could seek a writ of mandamus from the Ohio Supreme Court, asking it to order the Domestic Relations Court to proceed. But
Repeat
this,
that. I barely can hear you. I'm sorry.
well, here's the thing. This court does not have any authority to tell another court what to do. All right. So I'm going to deny your motion to enforce. Now, there are certain other steps that you can take to try to get the relief that you sought from this court, but obviously that's something that you would have to do at this point on your own. Now, the other thing that was pending and has been pending for a while is the defendant's motion in limine regarding the use of a recording which purports to capture a conversation between the defendant and at least one, if not several, individuals at the Domestic Relations Court. The allegation being that the recording itself was made not by Mr. Bishop or the individual that he was speaking with, and in fact the state seems to concede that fact in its memorandum contra the motion to in limine. And the court did considerable amounts of research yesterday afternoon, and here is basically what I found. Normally, a statutory violation is not remedied by exclusion. For instance, if an officer stops an individual for operating a vehicle while impaired outside of their territorial jurisdiction, that's actually a violation of law. But because it's not a constitutional violation, a defendant would have absolutely no relief or recourse to seek any type of exclusion. Here, however, there are specific statutes, I should say, that number one, prohibit and outlaw the interception of oral communications, and there are specifically statutes that indicate, and I will quote, no part of the contents of any intercepted oral communication shall be received in evidence in any trial if the disclosure of that information is in violation of sections 2933.51 to 2933.66 of the Ohio Revised Code. That's 2933.62a. 2933.52a1 prohibits the interception of an oral communication, and the subsection A3 of the same statute prohibits the use of the contents of the intercepted oral communications. So it would appear that the defendant's motion in limine is well taken, and I will preliminarily grant that in order that the defendant or that the state not use the recording itself in its presentation of evidence in its case in chief, That does not preclude the state from introducing evidence from individuals who were either part of the conversation or individuals who overheard the conversation as it occurred and who have a source of knowledge of the contents of the communication, not from the recording, but rather from their own auditory senses. So the court will be putting on that entry. Now we need to address the issue of counsel, or maybe we probably should have done that first. It doesn't really matter because the last time we were here, when Mr. Iteum withdrew his counsel, the court did indicate and explain to Mr. Bishop that I would be reaching out to the Ohio Public Defender's Office to see if they would be willing to represent him. Thankfully, they were, and I explained to him that if they weren't, or if that didn't work out, that the court would very likely declare what's called a constructive waiver of counsel. So I've done a little research in that regard as well. There's a case out of the 5th District, actually, from April of last year. It's in re adoption of AMV. It's 2024 Ohio 1240 is the site. But basically it talks about the fact that in that case, 2 separate attorneys were appointed to represent the defendant in a parental rights matter. The rights are conveyed under a different authority than the constitutional, but it's pretty much related. And then after the putative father basically fired both of those attorneys, the court reached out to every other attorney on that county's court-appointed list, all of whom declined to represent the putative father. And the ultimate ruling was that the defendant had 2 options at that point. He could, A, hire his own private counsel of his choosing, or B, represent himself. But at this point, the court finds that it has done everything possible to afford Mr. Bishop his right to court-appointed counsel, but that if 2 were enough in that particular case, I think 5 is more than enough in this one. So the court is going to declare a constructive waiver of the right to court-appointed counsel, and I will explain to you, Mr. Bishop, that you have 2 options. Number 1, you can hire your own attorney using your own funds. Number 2, you can represent yourself. You understand that those are the 2 options you have?
Yes, Your Honor. May I have a chance to speak now?
As soon as I'm finished.
Yes, Your Honor.
I need to advise you of the perils of self-representation. I want to confirm with you that you did not go to law school, nor do you hold a law degree, correct?
Correct.
You've never been admitted to the bar of any state to practice law, correct?
Correct.
Well, here's the thing. If you elect to represent yourself in these cases, you will be held to the same standard as somebody who has been to law school, who has passed the bar, and who has the experience of practicing in the courts of Ohio. The court would not be permitted to advise you on how to proceed. You could very well miss certain opportunities to improve your circumstances or plead your case. And that would be a risk that you would be taking by the fact of refusing to accept the assistance of court-appointed counsel.
Objection to that motion right there, Your Honor. I didn't refuse counsel. They refused me. I would like that worded correctly. Sorry.
Well, Mr. Bishop, here's the thing.
They have all told me.
Here's the thing, Mr. Bishop.
Yeah.
Them not telling you what you want to hear is not the same as being ineffective, okay? You may disagree with what they have to tell you, but they know more about the law than you do. I'm fairly confident in saying that.
That wasn't the case, Your Honor. I was being forced to take a plea deal when I wanted to come to trial. That is illegal. That is against my judicial standards of right. Every single attorney you have given me so far has told me to take the disorderly conduct on this telephone harassment and they'll dismiss the VPO. And every single one of them has told me this plea deal that they are going to come to the prosecutor with and that they want me to take that. And I have said, no, don't you dare go to the prosecutor with that. I want a trial, and that's what I want. And they have all came up with this phenomenon of a idea. Every single attorney. And when I say absolutely not, I want a trial, let's prepare for trial, next thing you know, we get a withdrawal motion. Me and her didn't have no quarrel. She just put her efforts into a rape case over me. And that's the same thing with that Ed guy. He put that whole situation, same thing with the previous attorney, Todd, or what have you, his name. And then I also want to put on the record, Your Honor, that out of the 5, 2 of them never even called me. I never even was aware that they were appointed to me, and they never even emailed me, called me, nothing. There was no mail, nothing. I wasn't aware that even 2 of those 3 came forward. All I knew about was Zach Tabler, Ed Talium, Todd something and this Ariel Iolia